Whether you're a member of the Colorado General Assembly or a citizen who interacts with legislators, the first thing you need to understand to be successful in meeting your policy goals is how bills are created and how they move through the legislative process to become Colorado state laws. Learning the ins and outs of the legislative process is the first step a legislator must take to achieve his or her policy goals. Learning the legislative process helps each citizen understand how he or she can give legislators input on legislation and possibly help shape potential laws. The first step to drafting any bill is to turn in a bill request via email, phone, or in person to the Office of Legislative Legal Services. The bill request doesn't need to include the actual bill title, just the bill subject and what the bill should accomplish. Each bill request is confidential to the requesting legislator and to any lobbyist or constituents that the legislator chooses to work with. After the legislator turns in the request, it is assigned to a bill drafter who will assist the legislator in drafting the bill. The legislator may give the bill drafter permission to work with other persons, such as lobbyists and constituents. Without the legislator's permission, the bill drafter will not discuss the bill request with anyone outside the OLLS. Once the bill is drafted, the drafter sends a copy to the legislator for approval. Again, the bill draft is confidential. The bill drafter will share it only with the bill sponsor and other persons the sponsor may specifically identify. When the bill drafting is finished and approved by the legislator, the OLLS puts the bill into final form, known as the bill back, and sends the bill to the Senate or House for introduction. To get through the entire legislative process, a bill must be introduced in either the House or the Senate, go through first reading, at least one committee hearing, second reading, and third reading, and then be introduced in the Senate if the bill started in the House, or in the House if the bill started in the Senate, where it must again complete first reading, a committee hearing, second reading, and third reading. At that point, if the bill is amended in the second House, it must be returned to the first House for the Houses to resolve their differences. Once both houses pass an identical bill, the bill goes to the governor. The first reading of the bill occurs when the House or Senate reader reads the bill number and the bill title, and the Speaker of the House or the President of the Senate assigns the bill to one or more committees of reference. Legislative Council staff then works with the bill sponsor and the committee chairman to schedule the bill for a committee hearing. Before the bill is heard in committee, a fiscal analyst sends the bill to the affected state agencies for an estimate of how much the bill will cost to implement and uses this information to draft a fiscal note for the bill. Here in the committee hearing, the bill sponsor explains the bill to the committee and answers any questions. The committee hears testimony from persons who are present to testify or to have made arrangements to testify remotely. The committee chair controls the length of testimony, who testifies, and whether anyone testifies at all. The bill sponsor is responsible for contacting witnesses that he or she may want to testify on the bill, but other persons present at the hearing also may testify. Legislative staff will not arrange for witnesses either in favor of or opposed to the bill. Following completion of witness testimony, the committee may consider amendments to the bill. Only committee members may offer amendments, but the bill sponsor may ask a committee member to offer an amendment on his or her behalf. The bill sponsor or a member of the committee who would like to offer an amendment should work with the bill drafter to prepare the amendment before the committee hearing. Once amendments are adopted or rejected, the committee takes final action on the bill, referring the bill to another committee of reference, referring it to the Committee of the Whole for second reading, or postponing the bill indefinitely. If a bill has a fiscal impact, it must be referred to the Committee on Appropriations before it can be referred to the Committee of the Whole. The amendments that a committee adopts are included in a committee report. These amendments are not final and are not enrolled into the bill until the committee's report on the bill is adopted on second reading. After the committee hearings, if the bill is not postponed indefinitely, it moves to second reading, which is a two-step process. First, the bill is heard in the Committee of the Whole, which is usually referred to as the cow. The cow consists of all the members of the House or the Senate. The cow considers and adopts, amends, or rejects the report adopted by each committee of reference that heard that bill. The cow may also adopt additional amendments to the bill before finally voting to pass or defeat the bill. All of the votes that the cow takes are either voice votes or standing votes, but none of them are recorded. Once the cow finishes, the House or the Senate, in a second step of second reading, must vote to adopt or reject the cow report, which specifies each bill and the amendments to each bill that the cow voted on. A member of the House or the Senate may offer an amendment to the cow report to reverse the action that the cow took on an amendment or a bill. The members of the House or the Senate vote on the amendments to the cow report and on the cow report itself, and each legislator's vote is recorded. Passage of an amendment to the cow report and final passage of the cow report requires the approval of a majority of the elected members of the House or the Senate. Second reading is complete when they adopt the cow report. If the bill passes second reading, it is placed on the third reading calendar for final passage. All the amendments adopted on second reading are enrolled into the bill. The new version of the bill is called the engrossed bill if the bill is in the first house. When the bill passes second reading in the second house, it is called the revised bill. Third reading is the final vote before the bill passes the House or the Senate. A legislator must get permission from the House or the Senate to offer an amendment on third reading, and generally, legislators may only offer technical amendments on a third reading. Once the bill passes third reading, any third reading amendments are enrolled into the bill, and the bill is called the re-engrossed bill if the bill is in the first house. When the bill passes third reading in the second house, it is called the re-revised bill. When the bill passes the first house, the re-engrossed bill is introduced in the second house. When it goes through the same process, committee hearing, second reading, and third reading, at each of these stages, the bill may be amended or defeated. If the bill is not amended in the second house, it is sent to the governor after it passes third reading. However, if the bill is amended in the second house, the bill must be returned to the first house because a bill cannot be sent to the governor until both houses adopt exactly the same version of the bill. Now, the first house can accept or concur in the second house changes, reject the second house changes and adhere to, refuse to change, the first house version, or reject the second house changes and ask for a conference committee to resolve the differences between the two houses. At the conference committee, 3 people from each house, 2 from the majority party and 1 from the minority party, adopt a report that amends either the re-engrossed or the re-revised bill. After this, each house may adopt the report and re-adopt the bill, or reject the report and either appoint a second conference committee or adhere to its version or adopt the other house's version. If the houses do not adopt the report of the second conference committee, they cannot appoint a third conference committee. If the differences between the houses cannot be resolved, either because they cannot agree on a conference committee report or because both houses adhere to their versions, the bill dies. Once the governor receives the bill, he has 10 days to sign or veto that bill. If he does not act within 10 days, the bill becomes law without his signature. However, if fewer than 10 days remain in the session when the governor receives the bill, he has 30 days after the legislature adjourns to sign or veto the bill, or the bill becomes law. If the governor vetoes the bill while the legislature is still in session, the legislature can override that veto with the approval of 2/3 of the members elected in each house. If a bill makes it all the way through the legislative process and is approved by the governor or allowed to become law, then it is published as part of the Colorado Revised Statutes and is implemented as law of the state. This is a brief overview of how a bill becomes a law in Colorado. There are many nuances and details that this video does not cover. The next step in learning the legislative rules of procedure, which are available on the Colorado General Assembly website. If you have questions concerning the legislative process in Colorado, please contact the Office of Legislative Legal Services.